Good afternoon, everyone. Uh, on behalf of Payments Council of India, I welcome everyone to this webinar on understanding the draft DPDP rules and its impacts on digital payments. A few house rules before we jump into the discussion. As more and more members join in, I would request all the members to keep their mic on mute. We will try and take questions during the session as well. What we will do is we will call out specific spots where you may please raise your hand and call out your questions. In the interim, you may also please drop in your queries, your questions in the chat. We will collate all those questions and we will prompt those questions one by one to the team. With this, allow me to welcome the speakers for today. We have Mr. Anu Tiwari, who's the partner and head of FinTech and Financial Services practice at Cyril Amarchand Mangaldas. Along with him, Jian Johnson, who's also a partner at the firm. With this, I welcome the team and I request them to start with the discussion.
Hi everybody. This is Abhijit. I'm a partner at Cyril Amarchand Mangaldas, and I'm part of the financial services team as well as the dispute resolution team. So today I have with me Hamraj, one of our senior members at the firm, and Abhyuday, who's also one of our associates who's been working very closely with the Digital Data Protection Act. So I'll just set some context as to how we'll go about this presentation for the time being. In the meanwhile, our team will put up the deck, which predominantly concentrates on the new rules, the draft rules that have come out in January. So a couple of points that I'll just highlight in relation to the Act itself. So this is the first of its kind Act, which is in line with what the international community, including Europe, the GDPR, something similar to that, which is now being enacted in India itself. But only caveat over here is that the Act in itself, while it has been published in the Gazette, it has not been notified, meaning that the Data Protection Act, the Principal Act itself, is not in effect. But be that as it may, once the Act is notified and the rules are finalized after the draft comments, etc., that come in, it is revised, if at all, this will kick in and it will continue to be applicable henceforth. So we can move to the first slide. So I'll just hand over the baton to Hamraj to take you through the main features of the rules, of the DPDP rules, as they call it. Raj.
Thank you, Shatriji. And so starting on the DPDP rules, that draft rules that have come in, and as of now, given it's in draft stage and it's open for public consultation and any feedback that industry body, individuals who feel that their feedback might help, it's open for submission of feedback till February 18th. Now, how we see the rules coming into picture is they have said, as in currently the draft proposes two separate sets of notification dates for the rules, and they have categorized like the generally applicable provisions around data privacy, notice requirement, consent, the security standards, the processor related obligation, rights of data principle, which are contained largely from rule 3 to 15. Then rule 21, which talks about the appeals to tribunals, that and any information that that the government can seek from the data fiduciary or intermediary, that is rule 21. These three sets of rule will come into effect in when there's a particular date stipulated whenever the Gazette notification comes out?
All right. So, adding on to what Hamad said, so one of the first consultation meetings that happened with MeitY, 1 week post the release of the draft rules, one of the first questions was why is there not a prescriptive format of how the notice should look like? The only instructions that have come in the draft rules, as you can see on the slide deck as well, is that it has to be presented and understandable independently, and it should have an itemized description. So the preliminary views of MeitY on this, and it's subject to all of the feedback that is going to go in till like February 18, is that they are not planning to be prescriptive. That is, and which is the general approach they have followed towards the implementation of DPDP Act, is that they aim not to be prescriptive and rather keep the rules principle based. So the clarity that we can see from this, right? So the expectation is to just simply have it in a plain language, where there is an itemized description of what data is being utilized for what purposes and is going to be processed for what purpose. Along with that, in the rules, there is an expectation to notify the data principal of how can they exercise their rights. For that, while there was a lot of lack of clarity in that sense as to what are the rights and how exactly is this to be part of the pop-up notice, for example, the preliminary views of MeitY is that for the rights, which is effectively making the data principal aware of the grievance redressal method, the details of the data protection officer, all of those can be provided via link. Right? Moving on to the next slide, which is about consent managers. So on consent managers, this is substantially a new requirement as when we compare it to the GDPR or the PDP that exists in Singapore. One of the biggest alignment of a consent manager is very similar, is there is a prescriptive schedule given of what is the application process for a consent manager, what is the obligation, what is expected out of them, and at the same time in group situations so where there is a flexibility for the bank group to have a group-wide consent manager. The only provisions to that is that there are certain stipulations within the schedule in relation to that there should not be a conflict of interest at the KMP level or the director level. So it allows specifically, so our understanding of this is that the NBFC account aggregator framework, which allows sort of one entity to pull data from all of financial institutions and share it with other financial institutions. This consent manager framework reflects a similar tone, and therefore our understanding is that currently licensed NBFC AAs can enter in this new business of being white label consent managers, which can go beyond just financial entities. Right. There are certain eligibility criteria and other sort of stipulations that are there. But given that we are all participants in the regulated space, all of these consent manager regulations and stipulations are not anything out of the blue, and are substantially in line, or I would say are inspired from how a regulated entity is sort of given their approval through RBI.
And just to add on to what my colleague has stated, there's a very objective criteria of a net worth requirement of INR 2 crore rupees, which is stipulated in the first schedule with the draft rules, which says that 2 crore requirement you have to meet in terms of net worth to at least be considered for registration as a consent manager. And this is one requirement on the capital front. Other than that, the financial condition, general character of the management, all of those checks that has been set out in the schedule with the draft rules for to be considered when they are being registered as a consent manager.
Moving on to the next slide. Right. So a data breach, the expectation in the Act in Section 8 was that there should be a intimation of the data breach that should be given to the data protection board as well as the data principal. Now, the draft rules gives certain clarity on it. As if so, one thing that we would like to preface here is that if you are an intermediary under the IT Act, then in the event of a data breach, you are supposed to report to the certain, and there are certain data items that have to be provided. The current sort of scenario is that now, firstly, there has to be an immediate report that has to go to the data principal as well as the data protection board, where general analysis, what is the risk, what is the exposure, all of those things are to be part of the data items of the data breach report that goes immediate. However, for the data protection board, another subsequent report within 72 hours has to be given, which gives a detailed analysis of all of these facts. These have been itemized in Rule 7. And so the point which bases our analysis is that while there exists a subsequent report that needs to go out to the data protection board, such obligation does not exist for the data principals. And moreover, if you see the analysis part of the slide deck, you will see that there is a sort of obligation to one, give the intimation to the sectoral regulator, the RBI, SEBI, ADI, whatever is the financial sector regulator that is applicable. You have to give it to certain. You have to give the intimation to the data principal and the protection board. All of these have substantially different obligations when it comes to what are the data items that need to be shared with that respective entity. That is something that, basis our experience, we're also the players are interested in seeking clarity on, and basically seeking harmonization of all of the content of these data breaches, so that it is time efficient to get all of these data breach notices out to all of those 4 entities as soon as possible and comply with the immediate expectation of it as per the rules.
And in fact, when the notification for any breach is being given, it's not just the breach that is to be intimated by the data fiduciary, but the data fiduciary should also include in the notification that what are the measures that the data fiduciary is taking to address the breach that has happened, and what is being implemented by the data fiduciary. So that's another level of requirement which has to be plugged in within the notification, breach notification. In addition to that, they have to also stipulate what are the safety measures that the data principal can take just to protect his or her interest in while the data breach has happened. And additionally, like, the data fiduciary should also provide the contact information that the data principal can reach out to and address any of his or her queries that they may have to deal with the data breach.
So just to add over here, currently how the regulations and framework work is that if there is any cyber attack, now it is predominantly and particularly in relation to cyber attack. And in relation to a cyber attack, there is a requirement to intimate to CERT, which is the regulator who monitors and addresses cyber attacks. So these points that the colleagues have just pointed out are already present in the current regulation vis-a-vis CERT-IM. Additionally, in relation to IRDAI, for example, there is a requirement to intimate to IRDI within, I think, if I'm not mistaken, within 24 hours. Whereas CERT-IN, it is 12 hours. RBI is again a shorter period, a longer period as compared to CERT-IN. So there are requirements already built in the current regulation that talk about cyber attack and intimation to these authorities. Whereas under the DPDP, there is a specific requirement of talking about data breaches because they would be typically a result of the cyber attack. So that's one point that I just want to highlight. I think we can move on to the next slide.
So another new aspect, which was part of the rule-making power, was what are the reasonable security safeguards that a data principal should be implementing, right? A data fiduciary should be implementing. Now there is substantial clarity on that when it comes to Rule 6 in the draft rules. And there are specific tokenization, access control, and specific measures that are and confidentiality measures that are built into and expected out of a data fiduciary. However, if basis our analysis as far as the implementation of these would play out in the context of financial entities and specifically regulated entities, these obligations are not, in our preliminary analysis, not over and above what financial entities are already following. They are very much in line with what is the market expectation plus the market standard which has been set by the respective regulators. And this would substantially impact non-regulated entities which did not have appropriate safeguards or appropriate measures already implemented as far as their information security processes go. So a gap analysis is something that should be that would be undertaken, because the DPDP Act is very clear in this regard that if there is any higher obligation that exists in any other law which with respect to data protection, then that is the one that should be followed. So for financial entities, if the understanding distills out of the final rules that the expectations in the DPDP Act are not higher essentially than what is prescribed by financial regulators, then there is essentially the expectation would be that no additional measures would have to be implemented by the financial sector entities, keeping only and only the DPDP Act in mind.
And linking this back to the point that we started, this is a principle-based law and not a prescriptive law. So when you see the requirements under Rule 6 for the reasonable security safeguards that are to be taken, these are the minimum stipulation that the rule provides for, which includes encryption-related measures, masking of any ID proofs, any virtual tokens, and all of that. So these are just the minimum set of standards that every entity will have to comply. But given the implementation around personal data, as in or the KYC data that the banking BFSI industry as a whole they are already addressing, this is something not very onerous for at least the BFSI sector, but certainly for any other technology company and all who is not having these minimum set of standards, this gap analysis helps them.
So additionally, there are already regulations and law in place specifically by RBI, IRDI, etc., which talk about data localization and data security. The Act already contemplates that the stricter of the two, that is the sectoral regulators' regulations or requirements vis-a-vis data as compared to the DPDP requirements with data, the sectoral regulators, which is typically the higher threshold, would prevail. However, in terms of areas which are not prescribed by a regulator. For example, consent manager or age gating for that matter. For those areas, we'd have to conduct a gap analysis to understand the delta between what is existing basis the sectoral regulatory requirements and the DPDP requirements and bridge that gap so as to address it in a holistic manner. You can move to the next one.
Right. So another sort of point clarity that is required out of the DPDP rules or the draft DPDP rules at this point is what is the retention period for data that has not been interacted with, right? The rules, so the corresponding section of the act that says that as soon as it is reasonably assumed that the specified purpose is no longer served, and the prescription from the central government has to come as to what time period is applicable for what class of data fiduciaries, that it can be deemed that it is no longer being served. Now, when it comes to the purpose, the rule read with the Schedule 3, there are only 3 types of entities that have been provided for when it comes to what is the clarity has been provided for data retention period. First is e-commerce entity with not less than 2 crore users in India. Second is online gaming intermediaries with not less than 50 lakh users in India. And social media intermediaries with not less than 2 crore users in India. For all of these 3 types of entities with the specific user threshold, the term has been given as 3 years before it can be deemed that it is no longer being served. However, what we require clarity on, specifically when it comes to BFSI entities, is what is the data retention time period that would be applicable to them. Now, there is a possibility that the MeitY has not, given the fact that MeitY, by the virtue of the IT Act, regulates online gaming intermediaries, regulates e-commerce entities, regulates social media intermediaries, the possibility exists that there was no specific sort of instruction given for BFSI entities, and the expectation is in the sectoral regulator to bring clarity to the same. However, that sort of clarity will only be possible once the final rules come about. But basis our experience, that is one of the points that BFSI players and major BFSI players are interested in clarifying from those rules, and the representations are going accordingly.
And in fact, before on this 3-year timeline, like let's say at the right after the expiry, you cannot go ahead and delete the data which is there. There is an intimation requirement 48 hours prior to that time for erasure that is expected, that of notification is being given by the data fiduciary, which is applicable to the social media platform, e-commerce entity, online gaming intermediary, that you have to give a 48-hour notification that the data eraser trigger will happen for the particular data principle. So that's there. In addition to that, there are certain 2 carve-outs under the head which has been provided, where the user account cannot be deleted, like the use data principle should have the control of the user account, and that cannot be deleted. That's a carve out from the deletion erasure requirement, which is stipulated in the 3rd schedule. And in addition to that, if there is any virtual token which has convertibility to money, that also cannot be deleted, and the user, being the data principal, be blocked from accessing those. So these are the 2 carve-outs that that MeitY has thoughtfully included within the carve-outs for eraser aspect, so that any data principal who's having any user account or any virtual token, etc., they are not affected.
I'll move on to the next slide. Right. So one of the other sort sort of which Shatrajit was also mentioning, is that when it comes to age gating processes, basically having a specific age determination for whether you will be able to process the specific data or not. Now, the rules explicitly state that for any child, there has to be verifiable consent that is obtained from the parent. And accordingly, those only then will you be able to access the website. Moreover, the obligation exists within the act that it will not be used for any detrimental purposes and all, which are in line with what is the expectations under the PDP that exists in Singapore and the GDPR when it comes to data processing of minors as far as it goes. However, we still feel that there is, while the draft rules were still in process and were not out, there were certain news sources that were, and there were statements by ministers which clearly stated that they are contemplating whether a specific type of technological solution can be implemented for verifying this age. However, there was a lot of sort of buzz around that. However, when we come to analyze the provisions that exist in the draft rules today, unfortunately, or sort of it can be looked at in two ways. There is not a prescriptive way that they have gone forward with, that this is how you should verify and obtain the parental consent. What is expected is that proper due diligence is ensured on the part of the data fiduciary, so that in the event of a child, the parent is verifiable, and through DigiLocker or through any of the other methods or virtual tokenization. And in the event of a person with disability, the obligation lands with the lawfully appointed guardian of that person, which can be evidenced by several items. It could be a court-appointed, a designated authority. It could be essentially a reasonable government certificate appointing the individual as a lawful guardian. Moving on to the next slide.
So there would be, so coming back to your age gating aspect, I think there would be certain practical challenges vis-a-vis implementing it, because currently the way it functions, we have a simpliciter consent stating that I am of so-and-so age. So that might not hold true, or that might not be a sufficient check. But there are other jurisdictions like UK, France, etc. They have implemented age gating. Now the manner in which it has to be implemented or seen is something which is left. Sorry.
I think continue.
So
The question will prompt. There was some disruptions. Please go on.
okay. So from the perspective of actually implementing it, it is to the discretion and to the better judgment, for lack of a better word, of the regulated entities or the data processor. Now, there are multiple ways like facial recognition, then indication of your birth date, OTP verification, Aadhaar verification, etc., etc. Now, they have their own set of challenges that I completely appreciate, but these are the ways in which we have to bridge the gap and comply with the regulations, while at the same time addressing the practical difficulties which would be faced. But there are examples from foreign jurisdictions which can be looked at to address these situations. So we can move forward to the next slide. Unless anybody has a question right now, I'd be happy to answer. Or we can wait till the end of the session, however, Gaurav, you would want us to take it forward.
You can stop check. So if there are any questions requesting
Sure.
members to either please raise the hand or drop the question in the chat. I can prompt that. Either works.
Understood. So we'll continue. Then we'll take all of the questions together at the end of the session. That maybe it'll be better that way. Please.
Okay. Moving to one of the aspects which is about significant data fiduciaries. Now, with significant data fiduciaries, the general understanding in the Act is that given that they are dealing with a large volume of data, there should be additional obligations such as an impact assessment that should be undertaken by these entities for given that the nature and the quantity of data that they're dealing with. That sort of clarity is provided by these rules where DPIAs or data protection impact assessments are to be obtained, and a report containing the significant observations has to be submitted to the data protection board. Now, the lack of clarity exists in what significant observations would turn out to mean. Given that data protection impact assessment reports are not new to the, at least not new to the space, there is some clarity needed here, and we might need to look to other jurisdictions as far as it comes to understanding what would be the significant observations that the data protection board would expect, or we may see other regulations or certainly bylaws that exist to come out regarding what is the expectation, or even guidelines for that matter, on what is the expectation out of significant observations. Another thing is that while in the larger sense of things, the Data Protection Act does not sort of, I see a question. We'll take it up, yeah. So while the Data Protection Act does not necessarily intend to provide for data localization, but basis these draft rules and specifically the obligation to, as it comes to the significant data fiduciaries, is that the Act only prescribes that you will not be able to process the data in countries which have been notified by the Government of India. However, the draft rules go a step beyond and say, does anyone have a question on this one? Happy to pause here. All right, continuing. So the point I was making is that the draft rules go a step beyond, where they have to basis the recommendations of a government committee. If it can be decided which subset of class of data cannot be processed outside India, and this would include personal data and traffic data. This cannot transfer outside India. Now, this in our analysis seems to go beyond and is a departure from the DPDP Act's original provision of a negative list. And we will have to wait for the final rules to come around to understand how it is tied into that rule, that Act section and the obligation under the Act that exists.
So I'll just clarify. So, subject to any questions that are there. So Section 16 of the Act, it provides that they will prescribe certain territories or countries to which the data cannot be sent to. Now, while the principal provision still continues, in the rules, what it is being contemplated is a list of data points or items which cannot be processed outside India. So there might be 10 data points, out of which 5 can be processed outside India without any restriction vis-a-vis which jurisdiction outside India it is being processed in. But the other 5 data points cannot go to any other jurisdiction, whether it is EU, USA, or any other FATF compliant country, or any other land bordering countries for RBI personnel over here. It can be sent anywhere. That is the understanding from the rule. I would have to wait and watch and see whether they further distill this rule to include what was previously contemplated under the Section 16 provision of the Act. Continue.
And just to point out another aspect is that by RBI already has a total data localization restriction when it comes to storage of payment data. So this once an SDF is notified when that happens, for at least the data when it comes to storage of payment data, the RBI circular would continue to supersede obligations under the DPDP Act, because that puts the absolute bar on any storage of payment data to go outside India. So, however, for other kind of sensitive personal data, which was earlier or as of now regulated by the SPDI rules or the sensitive personal data IT rules, that harmonization would have to be seen one for all the other kind of sensitive financial data, and what is the expectation for normal data fiduciaries, and how does it change for significant data fiduciaries. Moving on to the next slide. Right, so this is in continuation to the points that we raised before, that while the DPDP Act envisaged a negative list of countries, the new understanding is that it has to also require, so a specific rule 14 is of interest here, is where it has been stated that it cannot be transferred, data cannot be transferred to any foreign state or to any person or entity under the control or any agency of such state. Now, while our understanding and analysis of this is that the traditional control rules when it comes to, and funding rules, are to be understood when it comes to understanding whether a state entity that may as well be a BFSI entity is being funded by the state a foreign jurisdiction. That sort of clarity would have to come from the already existing jurisprudence that exists for control. But only preliminary, we were only able to get preliminary views from the MeitY in the consultation that happened. Is that right? So what they understand is that funding, control, and if a certain entity operates under specific foreign state policy, all of those would be substantial points of understanding whether an entity would fall under this rule and thus be restricted from carrying data outside India. Moving on to the next slide. Right. So I think
that's all on the deck from our side.
Okay.
All right, Gaurav and everyone from PCI team, all the attendees, thank you for joining this. Happy to take on any questions separately through Gaurav. So thank you, everyone.
Thank you. Thank you so much. Thank you, everyone, for taking time. For any further clarifications and questions that members have, I've dropped in my email ID. You may directly write to PCI, and then we will socialize this accordingly. Thank you so much.
Thank you, everybody. Thanks.
Thank you.
Hope it was helpful.